then you are able to add on to the submission. So you can present the submission.
Thank you, Chair. Legal Aid Board appreciates the opportunity to add its voice at this stage of proceedings, more especially that this particular bill touches on making access to justice for all a reality. And we see generally, before we get into the substantive provisions, the articles that are in this particular bill, we note that the provisions work to speed up the delivery of justice and decongest the higher courts, like the High Court and the subordinate court. We could end up having a number of cases being handled very quickly through the small claims court, and this is a very welcome move. We did look at the bill and what it provides. If I could just run through. In the first article, that is the standard provision that merely tells us what this bill, if passed into law, would be called. It is the standard way that our laws in this country are phrased. Then we did note that in the second article, there is a correction of an error. And throughout this bill, there are a number of errors that are being corrected. When it made reference to Article 109 as the provision creating the Judicial Service Commission, that is not the correct position of the Constitution. So in that regard, what the bill is putting forward is a welcome position, so that it remains that this commission is created under the Constitution of this country. And also we see that the bill provides a bit of clarity by including not just the person who is starting an action as a claim, but even the response, a counter claim, also being covered. This has been the practice in the small claims court, but it did not have the legal backing for it. And we see that this bill comes in and provides that legal backing for what has been happening. We've seen a number of new terms that have been defined, making for clarity that later on in the bill, when these terms are used, there is precise understanding in terms of what they refer to. In the third article, we did notice there the limitation in terms of the jurisdiction to a small claim. This is just making for clarity by defining that this is a court that shall deal with small claims, and there's clarity that has been provided in terms of what exactly are we talking about when we say a small claim. I must be quick to mention that the small claim has been defined. It may not be small for every citizen in this country for the limits that are usually prescribed. But when it comes to the law, there will be clarity in terms of what we are talking about. What is provided in Article 3, Subarticle 2, is also, in our view, a correction where the word specified was used instead of prescribed. In our laws, prescribed make for better clarity, because we know that the law will provide for what is prescribed somewhere. Specified was a bit of a foreign word when we consider common usage within our statutes. Most of what we see there is a correction where the word right was used instead of rent. But material to Article 3 is the extension of the jurisdiction to include matters arising from the Money Lenders Act and employment matters. We were of the view that while it's the Industrial Relations Court of the High Court is in Lusaka, and you could launch some of these matters in some districts like Kitwe, Ndola, Livingstone, you will find that there are many towns that are not covered by the High Court. And so, to have some of the employment matters dealt with by the Small Claims Court, especially for small amounts, was a welcome move. The same going for matters arising from the Money Lenders Act. So the extension in terms of the jurisdiction was perceived to be a welcome move, and legal aid board is in support. Then we also noted in Article 4, to the extent that it amends or it deletes it proposes to delete section 6 of the Act and replace it with a new one where the appointment of commissioners is now to be done by the Commission. This is the Judicial Service Commission, in consultation with the Chief Justice. Previously it said the current position is that it is in consultation with the President. This aligns properly because we are talking about the Small Claims Court carrying out the judicial function. And so to have the Chief Justice be the one involved as opposed to the President sits well from the point of view that we looked at as Legal Aid Board, and also we are of the view that this particular function will be undertaken much quickly, looking at how many things point to the President of the Republic of Zambia, and to have the President involved in the appointment of commissioners appeared to be a task that was not sitting very well. The position reflected in the proposed article, in the proposed section 6, subsection 2, where commissioners are to operate on a part-time basis, is merely a reflection of what is already happening. They already operate on a part-time basis. There was no basis for that reflected in the Act, but now the Act is being very clear that this position is on part-time basis. We did notice a rather, allow me to use the word strange provision that set out to limit the tenure for commissioners. So previously there was no such provision, and indeed we do not have such a provision with regard to other judicial officers like judges, magistrates. There is no limitation. However, here we've got a proposal that commissioners shall be appointed for 5 years. They may be appointed for a further 5 years, and that is the final. So a person can be a commissioner for 10 years and no more. So we had to apply our mind to the good that such a provision would save. Whilst in more urban areas like Lusaka, where we've got a number of people that can be appointed as commissioners, there are areas where there will be a smaller pool of people that may be appointed. So once you have had your 10 years and you cannot be appointed a commissioner anymore, what is going to happen in those areas? However, because this is a part-time role and we are increasingly seeing more people that are qualified to sit as commissioners, we thought perhaps having all the fresh minds come on board, given, yes, that those who've served as commissioners for 10 years would have gathered a lot more experience, but because this court deals with small claims, it is a position that we can live with. So it was supported from that particular perspective. We also noted that the bill proposes to clearly specify when the appointment of a commissioner may be terminated by death, resignation, legal disqualification, or conviction for a period of more than 6 months without the option of a fine, bankruptcy, or involvement in active politics. What amounts to active politics has been clearly defined. And so, because this is being put forward upfront, everyone will know that if I want to be a commissioner, I cannot be involved in active politics. And this is in keeping with the independence of the judiciary and people that are adjudicating over matters not being seen to be biased in any way, so that justice is administered without fear or favor. So we do support this position. We cannot have a person who is an undischarged bankrupt serving as a commissioner, or someone in active politics, and so on. So this particular provision was supported from that particular angle. The next article, which is Article 6, which seeks to amend Section 12A, is in keeping with what I have already referred to, where a counterclaim also comes within the scope of the Small Claims Court, but more, it also sorry, one moment, Chair. So I'm referring to Article 12A, which extends who may commence an action, and it says a person. A person has already been defined under our law. It also includes corporate bodies and unincorporated bodies. The definition of a person is not being put forward, and the existing law doesn't define a person. But we've got a definition in the Constitution that we can fall back on. It may be a subject of litigation for some people, because the word that was previously there was individual, and it was understood to be a natural person. Now the bill proposes to use the term person, and so we will therefore assume that person includes a corporate body. And even in the existing law, a corporate body is able to appear before the Small Claims Court. So this is a welcome proposition. In Article 7, to the extent that it proposes the deletion of Section 13 of the Small Claims Court and substitution with a new one, we see that where it had said a legal practitioner shall not appear before the Small Claims Court except if he is defending his own matter. Now it gives a position where an employee or an agent of a corporate body, unincorporated, can appear. Potentially, here is that a legal practitioner who is an employee of a corporate body can therefore now appear to represent that body as an employee of that body. So the prohibition that was there previously therefore falls off to that limited extent. And it just makes sense, because some of the corporate bodies, who are they able to send to speak into the litigation that they are facing, if not their lawyers? It is what is in their role profile. That is what their work is. So it just makes sense to have a provision like this. Previously, where just by virtue of your qualification as a legal practitioner, you are disqualified to appear, was not a proper position in our view. In in Article 8, which proposes to amend Section 16C, we see a position of law that is already practiced in the Small Claims Court, that it shall not be bound by the rules, the specific rules of evidence. This is what is already happening. It makes for clarity to just put it in the law so that it has a legal backing. The Article 9 is making a correction there. The word claimant was used, and so we have a correction there. It also goes on to say that the counterclaim shall be subject to the same limit as the claim. So if you've been sued for 75,000, you are not going to the Small Claims Court to counter sue for 3 million. You will have to be within 75. If you have a 3 million counterclaim, you are starting it as a separate action in a different court, because it falls outside the jurisdiction of the Small Claims Court, so that the commissioner will really be dealing with matters that are within their jurisdiction. So that particular specification is a welcome position. In Article 10, we had Section 21 talking about the rules for enforcement. Those that apply for the High Court will have been adopted for the Small Claims Court. But this particular provision merely comes in to say that even the rules of the Subordinate Court Act and the rules of the Debtors Act can be adopted when it comes to enforcement. And this just gives, expands the scope of what a person can do, their choices in terms of enforcement, and it is a welcome position from that angle. The next article, which is 11, Chair, I will speed up. The next article, which is 11, also talks about something that is already happening. It is the rules of natural justice. You can't be a judge in your own cause. So where a commissioner had a matter, and then there is a review by 3 commissioners, that commissioner cannot be part of the 3 that are reviewing, because they will be then reviewing their own position. Even without it being in the law, this was already the practice. Now this provision just comes in to reflect what is already happening and give it legitimacy from that particular angle. We have Article 12, which proposes to amend Section 22B by deletion of subsection 1 and substitution of a new one. There it comes to the position now, if a panel is sitting, the 3 commissioners, it just says their decision shall be by majority vote. It is also something that is already happening, just being given the legitimacy. Article 13, which is the repeal of Section 24 and substitution of a new one, is also to just bring in the rules of the Subordinate Court and the Debtors Act. Article 14, which proposes the repeal of Section 25 and substitution with a new section, increases the penalties for obstructing officials of the Small Claims Court. So over time, money does lose value, and when you look at what was in the law, 400 penalty units equated to 160 kwacha as the maximum fine that was provided. It was too low. It didn't make sense. And in fact, one would say it provided motivation for people to obstruct, because there was no pinch that was being felt. but now the bill proposes to raise this to 20,000, which is an amount that, compared to the maximum you can put before a small claims court of 75,000, 20,000 is a significant amount. So it will act as a deterrent. And so we support this particular amendment. The same thing goes for Article 15, which also provides for the amendment of Section 26 to also increase the penalty to 20,000 kwacha. Also, the same thing is happening in Article 16, which proposes the amendment of Section 27, raising the penalty to 40,000 kwacha. The amounts that are existing currently are ridiculous. 320 kwacha as the maximum is too low. Article 17 specifies that the small claims court shall have its own fund, and what is happening there, as opposed to the permanent secretary in the Ministry of Finance running a revolving fund, the small claims court is being given its own fund, and an amount may be appropriated to it by Parliament. This would be a small step but quite significant towards the independence of the small claims court from a financial point of view. And this fund, that is where now the small claims court will be putting its fees and all that. We do not support the current arrangement of it running a revolving fund under the permanent secretary, Ministry of Finance. We support this position where the small claims court will have its own fund. Article 18, which provides for the amendment of Section 29 by deletion of subsection 2 and putting in place a new subsection 2, provides that both the person starting the matter and the person responding to it will pay fees. This is fine, because as opposed to just the person who is starting the matter paying the fee, when a person counterclaims, they are also starting their own matter, and sometimes it is different in nature from what the person claiming against them is claiming. So it only makes sense that they pay the fees. This aligns with what is happening in all the other courts, the High Court, the Subordinate Court, and the other superior courts. The person who is responding or the defendant also pays fees. And these fees go towards the operations of the given court. The last article that the bill proposes is Article 19, which seeks to amend Section 31 by deleting one subsection, which is E. And what this does is that it now leaves the emoluments for the commissioners to be decided by the Emoluments Commission. And this aligns with generally why the Emoluments Commission was put up in the first place, and so in that regard it is a welcome provision. Generally, you will notice that this particular bill proposes to amend a number of sections. The sections that it proposes to amend are a lot, and also considering the fact that in the year 2008, by Act number 14, the Small Claims Court was again amended, at that time. So it therefore means that for any ordinary citizen to understand what the provisions of the law are in respect of the Small Claims Court, they are now going to sit with 3 documents. The Small Claims Court Act, they will sit with the Act number 14 of 2008. Then if this is passed into law, they will now sit with this as the 3rd document. Because the amendments are material, we were of the view that it would have been better to repeal the entire act and substitute it with a new one. The reading is so complex that now one has to look at what is the provision of the act itself. Was it amended in 2008? After that, check whether it is now being amended again a 3rd time. If it was just a few sections being amended, it is fine. But where the changes are substantial, we are of the view that the entire act should have been repealed and replaced with a new one. Chair, those are our submissions. So generally we are, as Legal Aid Board, we do support the new bill to the extent that it corrects the typos and the errors that we see on the face of the act. We do support the new bill to the extent that it enhances the penalties for offenses under the act. And we do support the new bill to the extent that it proposes to further enhance the independence of the Small Claims Court. I submit, Chair.
Thank you. Let me give a chance to the members, those who have questions and observations to make over the submission. Yes, Honorable Zulu.
Yeah, thank you, Chair. Witness, good morning. I'm Minyanzo. I didn't introduce myself.
Good morning.
On 4, what is your take? Because you are saying you are in agreement that the Chief Justice and the Commission should appoint the commissioners. What is your take? Because commissioners and Chief Justice are just human like us, and they can err. For the sake of transparency, why don't we, what is your take by advertising the position for the commissioners so that a good number of people can apply? Because appointment, what I've noticed is that people just confine themselves to Lusaka. At the end of the day, only people within Lusaka will be appointed. Meaning those who have graduated and living in Livingstone, Choma or Chinsari, they might not have an opportunity to be given such a position. And you may agree with me that there are a number of law graduates out there who are not doing anything. In addition to that, it's on 14 and 15. I agree. Okay, for 16, I won't talk much about this, but on 14 and 16, I live in a very small town, very small district, and we've seen one person losing a property because he differed with the wife, because the wife was going with a court officer. This is reality. And the person almost lost the house if he didn't engage a lawyer from Lusaka, and I fought to bring the case into Lusaka. That's how he retrieved back his house. Now, the 20,000 kwachas, the 500 penalties, and on both 14 and 16, don't you think this is too harsh for ordinary people? Some of them are maybe genuinely ignorant about the law, and they end up arguing with an officer, and the officer uses this act to penalize the very person. I thank you, Chair.
So far we have 2. Yes, Honorable Musanja.
Thank you, Chair, and thank you, witness. On your point number 7, you are happy with the bringing of legal practitioners to appear on behalf of a corporate or an incorporated body, provided the legal practitioner is an employee or agent of the corporate or an incorporated body. Don't you think this provision will skyrocket the cost of litigation, in that the original spirit of the Small Claims Court was to make it cheaper and easy for one to claim, you owe me a 10 kwacha, I take you there and we argue our case and you give me my 10 kwacha. Now hiring lawyers will require 25,000 to be deposited when I'm looking to claim a 10 kwacha. What is your comment on that?
Yes, Honorable Amata.
Thank you so much, Chair. My question is on the commissioners who are to serve for the maximum of 10 years or 2 terms. Witness, could you give the rationale behind the limiting of the term, bearing in mind that usually we would want to see experience, especially when it comes to such matters? Thank you.
Maybe we can attend to those observations.
Thank you, Chair. Starting with the appointment by the Chief Justice and the reference that the Honorable mentioned, that commissioners are just humans. Our reading of this provision does not speak into the process that the Judicial Service Commission will undertake in terms of coming up with the names on who they appoint. This process may well involve the advertising and all the other processes, but when it comes to the appointment, this provision is providing that the appointing authority shall be the Judicial Service Commission in consultation with the Chief Justice. Perhaps for us to have a more transparent appointment process, we will be looking not to this act, but we will be looking to all the acts that govern the operations of the Judicial Service Commission. That would be the more appropriate place for us to go and refine and make it all inclusive. That would be my reaction to the first one. There was a mention that perhaps the penalties that are being put forward are too harsh. And the Honorable Member did make mention that 16, maybe not so much. But if we look at what the offenses are in 16 masquerading as a commissioner. A person who pretends to be a commissioner of the Small Claims Court cannot plead ignorance. Then if we talk about obstructing an officer of the Small Claims Court, these are people that are given identification. We are talking about small communities where these people are known. And even where the person can claim that they did not know, or there are circumstances that would explain their behavior, because it is a criminal act, they will be brought before a court who will hear them out. We want to believe that our justice system does afford someone an opportunity to explain themselves. So if there are these peculiar circumstances that it was accidental, the thinking is that they will be able to explain before the criminal court, where they will be brought to answer to this charge, and it shall be put forward, and hoping justice will prevail. So from that particular angle, we do not think that because of the quantum of the fine, innocent people are in danger. And in any case, the 20,000 is the maximum. The court will then be able to determine, depending on the circumstances, what the actual amount will actually be. It might be less than that. There was a question on allowing lawyers and whether this will then increase the cost of litigation, that this would go against the original spirit of having the small claims court, where people could all walk in as individuals, the same way that we all would walk into a local court and there are no lawyers there, and the litigation is very fast and anyone is able to speak on their own. The provision of the law as it stands here is not this employee who is a lawyer appearing and now operating as a lawyer. That's not our reading of the provision. But you see, because a company is an artificial person, it has to operate through some agents. And so if the agent who is available, who knows what happened and can speak into the material facts, is a lawyer, that person should be allowed, as opposed to being blocked just by virtue of being a lawyer, to say you can't step here unless you are litigating in your own matter. So we thought from that particular angle there is no added cost, because that lawyer is an employee. We're not talking about going to hire lawyers and now those lawyers are coming to represent in the small claims court. So we are of the view that the spirit of the small claims court will not be violated from that particular angle, and there will be no added costs. There was a question on the rationale behind the limiting of the tenure. I wish I could speak into when this particular provision was put in, what was the rationale. Unfortunately, not being the ones that put in this particular proposal, we can only speculate. And that is why I mentioned earlier that when we saw this provision, we now had to think, what is the rationale behind? And now we had to just weigh what could be the pros and the cons. And the Honorable Member did rightly point out that experience in such matters is important. However, this provision is being put up and we are supporting it from an angle where you can't have certain people sit in these positions forever when we have many people that can potentially take up. It's on part-time. It's not what people are doing for their living. Being a commissioner is on part-time. So from that particular angle, we are saying that it is a provision that we can live with. However, we do acknowledge it is open to debate. It can be argued the other way around. Chair, unless I've left out one, I think I've responded to all of them.
Yes, Honorable Chinkuri.
Chair, thank you so much. I've got two concerns. I want to look at two provisions and want to establish the rationale of increasing these, fees. I want to look at clause 2014 in line with the I think, okay, yeah, that's 14 coming to 15, 17. It funds of the, yes, 17. Now, if you look at 17, we are saying repeal of section 28 and replacement with a new section 28. The changes provides for the small claims court to have its own fund to which an appropriation may be made by Parliament and under which the court is to continue collecting fees. So I just want to find out these fees that we are proposing to increase, are they as a result of funding of the claims court? The second one, just for curiosity's sake, you know, in a democratic dispensation, things need to flow. In event the chair here disturbs me, I need to go to a second person and, you know, ask for redress. Now in this case, in event someone is not satisfied with a small claims court, would that person find a leeway to appeal somewhere for redress? I submit, Chair.
Yeah, you can respond to those two.
Thank you, Chair. So the Article 17, to the extent that it proposes the repeal of Section 28 and replacement with a new one, does not propose an increase in the fees. What it does is that it says, as opposed to the fees being put in this revolving fund put up by the permanent secretary, there shall be a separate fund where the fees shall go. So it just talks about where the fees shall be routed. And in addition to the fees, it says Parliament can allocate an amount for the small claims court. It shall also go into that one. So from that particular angle, and just by this provision, there is no increase in the fees. So that would be my submission. The small claims court remains a final court, except on points of law. So if the small claims court determines that the one who owes the other is this one, there is no appeal to any court. That position is not changing by this bill, and we do support that position. We cannot have all matters progress all the way up to the Supreme Court, like we have seen some of the cases. If I may be allowed to talk about one case that was going to the Supreme Court because one person in Nakonde had cut a mango tree on the yard that belonged to the uncle, and we're going all the way up to the Supreme Court for the mango tree. So some of them, there has to be finality to litigation. And so the small claims court is designed in such a way that when you go there, you know that once determined, the matter comes to an end. So that we all now leave court and we move on with our lives, focus on production, as opposed to all of us, even non-lawyers, spending our entire lives in the corridors of the courtroom.
Yes.
Thank you so much. I think there is some misunderstanding of my rationale of asking this question. Probably, to clarify this, can you just delve a bit more on Article 14, where this proposed section increases the penalty for contravening subsection 1 from 400 penalty unit, which is 160, to 50,000 penalty units, 20,000 kwacha.
Okay. So our support for this proposed amendment is that 400 penalty units as the maximum penalty for someone who is offending came to 160 kwacha, because the penalty, each penalty unit is 14 ngwe. So that would come to 160 kwacha as the maximum. So it meant that even if the court sees that this person was not justified in obstructing an officer of the court, This is an officer of the court, for example, who goes to execute and say the court has ordered that this wheelbarrow must be taken, sold, and the money given to this person because you owe. And that person refuses or obstructs. So even if the court sees that this action is offensive, it offends and takes away from the powers of the court, the furthest that the court can go in penalizing this one, should the court choose a fine, is 160 kwacha. Now for 160 kwacha, most people would say it's fine, I will pay it. And so we'll see an increase in lawlessness because people can afford the fine. But if a person knows that they are in danger of a fine that they can feel, which has a pinch, it will then act as a deterrent. Thank you, Chair.
Yes. Now, which brings me to 17. The change provides for this, the small claims court to have its own fund. Now, this fund, as I know it, I stand to be corrected. It should be, part should be coming from Parliament, part should be coming from the fees that the court is, collecting. Now, would this there then cause or motivated for the increase of these fines as read in 14? Looking at it, it has to source its own funds. So this could have been a motivator to increase from 400 to 50,000. I submit, Chair.
Allow me to distinguish between fees and penalties. So the fees would be those fees that the person would pay for filing documents, the fees for filing affidavits, and the different things. Now when it comes to penalties, like we know within our penal laws of this country, there are a number of penalties. And where those penalties go is not to the fund of that court. So they are centralized. You are penalized for offending the laws, and if my understanding is correct, those penalties go to the central government fund. They don't go to that court. So these increased amounts we are seeing are penalties, not the fees that we are referring to in section 28. So from that particular angle, I don't think there would be a motivation, although I must be quick to say that even if that was there, I would still not be opposed to that, in the sense that as long as people obey the law, the 20,000 doesn't arise. And what we want is for people to obey the law. Thank you, Chair.
Okay, thank you. Unless there is another satisfied. Okay. Thank you, Legal Aid Board, for attending to the members to their satisfaction. The small claims court is to deal with this word small. The word small, has it been defined? Small, right? Okay. They're very small, right?
There is a definition.
Just on a lighter note, if you went to Karamo, in my village, and then you tell me, Lavmo, that 70,000 is small. Surely, how many people agree with you on Abamata? In my village, 70,000 Small. 70. Okay. Thank you, Legal Aid Board.
Thank you, Chair.
Let us take away the immunity so that you go and use the powers there be with the legal aid. Thank you for today's participation. Good day.
Well, thank you for still being with us on Parliament Television. You're just from watching the Committee on Legal Affairs, Human Rights and Governance, in which the Legal Aid Board was making a submission for the consideration of the Small Claims Court Amendment Bill, National Assembly Bill number 16 of 2025. Keep watching Parliament Television, the only station that brings Parliament closer to you.
Utukashana tumotwa mulomo kave papa kafumapo kave panapa kafumapo evo katete. Utukashana tumotwa mulomo kave papa kafumapo kave panapa kafumapo evo katete. No tulumendo chimo chine kave papa kafumapo kave panapa kafumapo evo katete. No tulumendo etwachilamo kave papa kafumapo kave panapa kafumapo evo katete. Katete katwalo bufikwisano kalya katete katete katwalo bufikwisano kalya katete. Ego kayo kunkaya kipushisha ego kayo kunkaya kunaula ego kayo kunkaya kipayaine kalya katete. Ego kayo kunkaya kipushisha ego kayo kunkaya kunaula ego kayo kunkaya kipayaine kalya katete. Umuntu ubepo bufi umuntu ale katete. Umuntu ubepo bufi umuntu ale katete. Aikaliro kupande fiwanse no lwambo enchito yakwe ako amana konse kulanda tewakutusha. Aikaliro kupande fiwanse no lwambo enchito yakwe ako amana konse kulanda tewakutusha. Chalo nga wafulisho bufe ku bantu chileto mwenso. Chalo nga wafulisho bufe ku bantu chileto mwenso. Amayanda tampo kutobeka na bantu batampo kulwala ababipa batampo kuwayawaya evo katete. Amayanda tampo kutobeka na bantu batampo kulwala ababipa batampo kuwayawaya evo katete. Chishimwe bantu mafuliro bufi tutunge nyutunga twenu tukamireterera umuntu walwambu epaisha bengi watikatete kashabana mano ekukayo kunkaya kepushish ekukayo kunkaya kunaula ekukayo kunkaya kepayaini karyakatete ekukayo kunkaya kepushish ekukayo kunkaya kunaula ekukayo kunkaya kepayaini karyakatete utukashana tumutwa mulomo kave papa kafumapo kave panapa kafumapo ebukatete utukashana tumutwa mulomo kave papa kafumapo kave panapa kafumapo ebukatete notulumendo chimo chine kave papa kafumapo kave panapa kafumapo ebukatete notulumendo etwachilamo kave papa kafumapo kave panapa kafumapo ebukatete mayo ekonkayo konkaya kepushish ekonkayo konkaya konaula ekonkayo konkaya kepayaine karyakatete mayo ekonkayo konkaya kepushish ekonkayo konkaya konaula ekonkayo konkaya kepayaine karyakatete mayo ekonkayo konkaya kepushish ekonkayo konkaya konaula ekonkayo konkaya kepayaine karyakatete.
chete emana pita kurumu yache wada pansi mumdima ikuyamba kupempera mulira pempero yache inatero Mulungu ndipase ni chito Mulungu nipese ni kumatenda nipange nikukala okutira pazintu zingono zimene nili nazo nipase ni mtima osakumbwira zintu zaeni nipase ni lilimero lankola zintu zonadi nipase ni masona zabwino nipase ni mtima wachikondi ine mlonda wanga mchelo wa Mulungu chingirizeni mwana asana malize pempero la chema anambalizu ya tate ache kusimu ikuti kuona maso anko na mwana wanga teka mtima nguruwe dalila msampa utaninga bila mtima